Okay, so good morning to all of you, and all of you are muted, but I would assume that everyone are already on board for this very special, not only special, but legally required um, training. So this one, the subject matter that we have today, that you can see in the screen, which I uploaded for you to see as I move along in my presentation. This does not pertain to the COVID-19. Enough of COVID-19. Let's pause and talk about sexual harassment in the workplace, which occurs almost every day in the workplace. So if you can see here, the title of our webinar is Mandatory Sexual Harassment Prevention Training for Supervisors. So if you are not a supervisor, which I'm going to briefly define shortly hereafter, then you can excuse yourself. And so this is exclusively only for supervisors. There is also another sexual harassment training, which is a requirement also intended for non-supervisors, meaning your rank and file employees. But insofar as they are concerned, the requirement is only 1 hour. But supervisors, this is a required 2 hours training. Yesterday, I emailed Kina, the administrator, and Joe a copy of my presentation. Kindly print it. And not only that, I also send a copy of the quiz because the requirement under the law, we must show proof to the Department of Labor, just in case you will be subjected to an audit, that you have attended this training at least once every 2 years. So you must have your sign-in sheet now. Everyone should fill up the sign-in sheet. And second, at the end of this presentation, you should take the quiz that I have sent to Kina. And the quiz, you must include that or put that in the personal file of each of the supervisor that attended this seminar. So my name is Joey Tugong, and I don't know if all of you are more or less familiar who I am. I am a certified workers' comp professional and a certified risk management specialist and a juris doctor. I'm a consultant in the area of risk management for Primex. Reason why I have to introduce myself, because this particular training, it has to be conducted by a person who has knowledge or knowledgeable in that regard and duly certified to conduct this particular training. Through the years, I have attended a lot of trainings pertaining to sexual harassment prevention training. So therefore, I'm in a position to conduct this training. Now, this training, the components of the requirement is not only confined to having a quiz, but also I should share with you some case laws and also case examples of what a sexual harassment and sexual discrimination is. And not only that, I should also empower you or share with you some skills on how to conduct an investigation, because that is the requirement under the law. Hold on. Let me start with the caveat. A caveat is a Latin term for to place you on notice. It's a warning. So this presentation is not a legal advice. And examples and case studies that I'm going to share with you here is only for educational purposes. Now, as we proceed in my presentation, if you came to realize that you could have been subjected to a case or a potential case of workplace harassment, or you were in a situation that you have witnessed a case of sexual harassment that was subjected to a co-worker, then kindly report that incident to your human resource or the DSD perhaps, or your immediate supervisor, and including your administrator. So let's define first who are supervisors. Remember, I said earlier, if you're not a supervisor, kindly excuse yourself. So there are two definitions of what a supervisor is. One is federal and the other is state. And if you can see in this first slide, This is the federal definition of what a supervisor is. And under federal law that pertains to harassment and discrimination, the agency that regulates, that enforces the Title VII of the Civil Rights Act is the Equal Employment Opportunity Commission. So, briefly, an abbreviation, you call it the EEOC. So, if you can see in this first slide, the definition of what a supervisor is, it is an individual who has the authority to undertake or recommend tangible employment decisions affecting the employee, or has the authority to direct the employee's daily work activities. So in other words, you will qualify as a supervisor and to attend this training if you have the direct authority to undertake tangible employment decisions, or indirect. You might not have that direct authority, but you can effectively recommend, that is the indirect, to your administrator or to your immediate supervisor. And if you don't fall under this particular definition, the second qualifying condition for a supervisor is who has the authority to employees' daily work activities. In other words, you have one or more employees under your supervision. So if you don't direct activities of one or more employees under your department, you are just by yourself, you can still qualify as a supervisor, provided that you can effectively recommend to undertake tangible employment decisions. So what is tangible employment decisions? This pertains to the hiring, the firing of an employee, undertaking disciplinary action, demoting an employee. So these are what you call tangible employment decisions. Now, what is the definition of a supervisor in the state of California? And all of harassment and discrimination cases in California, other than the Title VII of the Civil Rights Act and other laws which were passed by the state of California, you can find that under the California Fair Employment and Housing Act. In short, you call that FEHA. Remember, federal, EEOC, California, FEHA, Fair Employment and Housing Act. So what is the definition under the state law? If they had the discretion and authority in the interest of the employer, one, to hire, transfer, promote, assign, reward, discipline, or discharge other employees. In the absence of that, this is the indirect, or effectively recommend any of these actions. Second, to act on the grievances of other employees, or to effectively recommend action on grievances. So what do you mean by to act on the grievances? Meaning if there is a complaint, not necessarily pertaining to harassment and discrimination, anything that falls under your employee handbook that an employee can address his grievance, and if that person can act on that grievance directly, or she has that authority, or can be delegated that authority to attend to the grievance complaint, then therefore, he is a supervisor. And of course, just like the federal law, to direct the claimant's daily work activities. So we are therefore clear. If you don't fall under this definition, state and federal, you can excuse yourself. And for those who were not able to attend this seminar, I suggest, because I am recording this, just like the previous two seminars that I've conducted, I uploaded it in the YouTube. I'm going to send you the link. Give it to them. They can watch this presentation in the comfort of their homes. And then at the end, give them a copy of the quiz, take the quiz, and then place it in their respective personal file. So with that being said, therefore, supervisors, therefore, belong to management. This is an area where, as part of my risk management job, that I have noticed that almost all supervisors, they take positions against management, not knowing that the position that they're taking is against themselves. All supervisors are agents of management. When I say agents of management, this includes the owner. So therefore, you act for and in behalf of management and of the owner. So other than yourselves, therefore, what we have are the rank and file employees. So you see, in a broad scheme, there are two classes of employees. One, supervisors, that belongs to management, and the other one are the rank and file employees. So your role is to act for and behalf of your employer, protect the interests of your employer, further the interests of your employer. You see, that is your role. So there are times where I don't understand why supervisors talk against their employer and defend or promote the interests of the rank and file employees. But of course, if the complaint or the concerns of the rank and file employees are considered to be legitimate, then therefore, you should serve as a facilitator. Then you discuss that with management. So that's why in labor union cases, supervisors are not part of a labor union. They cannot form a labor union. Why? Because they belong to management. So at least, let's be clear in that regard. Now, Lan, I hear voices, Lan. I don't know who is unmuted. Lan, can you hear me? I hear some voices. Lan? I hear some voices. Can you mute? Okay, someone is on. Can you unmute it? Okay, good. Because I am sorry, I get distracted if I hear cacophony of voices. So let's know the history of harassment laws and case laws. And so, the mother of all laws that pertains to harassment and discrimination, you should memorize. It's Title 7 of the Civil Rights Act, which was passed in 1964, signed by then President Lyndon B. Johnson. Actually, the one who introduced this particular bill was then President John F. Kennedy. But as a result of his assassination, then Lyndon Johnson, who took over, he was the one who introduced these two, both the House of Congress, the House of Representatives, and the Senate. So what is the Title 7 of the Civil Rights Act? Briefly, it pertains to the protection of certain personal characteristics of a person. And basically, under this particular law, there were initially only 5. 1, race, national origin, religion, sex, and ethnicity. You see? That was originally the Title 7 of the Civil Rights Act, where it provides that all employers in the United States of America, for purposes of employment, you cannot discriminate by reason of those 5 protected categories. They should be given equal rights. So in other words, this does not only pertains to the protection of the civil rights of an employee or of a person, but it also pertains to the labor aspect. Because when we apply for a job, when we are hired, then we should be given all the necessary protection. Of course, the background of this particular law was due to Martin Luther King, the civil rights movement. They fought for it with tears, blood, with their blood, with their heart. They fought hard for this until such time they were able to materialize or achieve their dreams. Then the following year, in 1965, Congress passed the Equal Employment Opportunity Act, giving the EEOC power to enforce Title 7. So therefore, the Equal Employment Opportunity Commission, a federal agency, was formed to enforce this particular law, the Title 7 of the Civil Rights Act. And you see the progression of this law. In 1976, the concept of quid pro quo was recognized by the United States Supreme Court. Quid pro quo is a Latin term, means for something for something. I scratch your back, you scratch mine. This is one of the types of sexual harassment which I'm going to discuss with you shortly later. And in 1992, there were a steadily increasing number of harassment filings began to emerge. Why? In 1991, if you notice, Justice Clarence Thomas, one of the few Black African Americans that was appointed to the Supreme Court, Anita Hill. She used to work with Clarence Thomas in the Equal Employment Opportunity Commission. She said that almost every day she was subjected to a hostile, offensive, sexually abusive working environment. So as a result of that, in 1992, there were a lot of sexual harassment cases that were filed, such that it reached the Supreme Court. So in 1993, the Supreme Court defined the elements of what a hostile work environment is. So basically, it is not the law, but there are two case laws which was ruled by United Supreme Court. The two types of sexual harassment in the workplace, which I'm going to explain more or less in detail. One is quid pro quo, the other one is hostile environment. So if you take a look at this in 1994, just to give you an idea, a trial court in California ruled that the law firm failed to end harassment, and the court punitively punished them, awarded plaintiff $7.1 million. Could this happen to Los Balos and Secrets? The answer is definitely yes. So, if management, you as a supervisors, you have seen, not only seen, but you have heard in the grapevine that an employee or a group of employees are being subjected to sexual harassment, and if you don't do anything, then what would happen is your employer will be culpable for such failure, for negligently, for failing to act those situations that is considered to be a case of sexual harassment. In 1998, Supreme Court ruled employees who refuse sexual advances of a supervisor, yet suffer no adverse tangible consequence, may still recover damages against the employer without showing the employer is negligent or at fault for the supervisor's actions. So you see how liberal the Supreme Court is. So in other words, what this means is that if an employee is going to solicit sexual activities from an employee, and if the employee refuses, and that supervisor did not subject any tangible adverse action, still management or the employer will be liable. In other words, the act itself will consummate already a case of sexual harassment. And even though the employee doesn't even have to prove that the employer failed to act on what the supervisor has done. So you see, it consummates immediately. This is how liberal the U.S. Supreme Court is when it comes to cases of sexual harassment. In 1998, the U.S. Supreme Court ruled same-sex harassment is actionable under Title VII, therefore protecting men as well as women. What does it mean? In other words, a male can file a case of sexual harassment against a male. A female can file a case of sexual harassment against a female. You see? So, it is not only confined to heterosexuals. The same sex can file a case of sexual harassment. And not only that, it has been expanded by a recent law which was passed in 2018 or 2019 in the state of California, LGBTQ. See? The lesbians, the gays, the bisexuals, transgender, and the queer or the questioning, they are a protected class. And if they subject you to sexual harassment, you can file a case also, a case of sexual harassment. In 2005, the state of California requires that all supervisors receive 2 hours of sexual harassment prevention training every 2 years. That is the reason why we are here. This is the particular law that we are talking about. And that's why you are compelled, you are mandated to attend seminars on prevention training pertaining to sexual harassment once every 2 years, AB 1825. Why? Because the number one cases during the last 5, 6, up to 10 years in California were as a result of sexual harassment, not sexual discrimination. These are two different concepts, which I'm going to explain later. 2018, the state of California requires that all non-supervisors receive a 1 hour of sexual harassment prevention training every 2 years. You see? They expanded it. Before, it was only supervisors. Now, including non-supervisors. But their training is only 1 hour. So what does it mean? So meaning, we have to educate our employees. So when we educate our employees now, they already have knowledge of certain situations, of certain instances that they can construe and even perceive that is a case of sexual harassment. Now, if you as a supervisor is going to undertake any forms of sexual harassment, your employee are not already naive. They know their rights and they can immediately file a case, a grievance complaint against you for sexual harassment. And you don't want that because there is a possibility you're going to lose your job and you could be personally liable. But what is worst? The stigma. In life, it is all about dignity. What face are you going to show to your family, to your friends, or in the community that you were terminated or fired because of sexual harassment? And not only that, you are doomed. Your future is doomed because there is a recent law that an employer can share that information. There is no such thing as privacy. If you were accused of sexual harassment, and if you apply in another job with another employer, that employer, if they request information, they can share that information. That there was a case of sexual harassment that was filed against you by a co-worker or by a subordinate. So you see, so your future will be done. So you have to be very careful then how you conduct yourself in the facility. So these are the following laws that we have in California. You must remember, in the 50 states of the nation, California is number one. It ranks number one. Very tough. We have lots of laws that protects employees from cases of sexual harassment or sex discrimination. And not only that, all forms of discriminatory conducts. There are 23 protected categories. Would you imagine? Other than the federal, they came up with other protected categories. This is how tough California is. And worse, if a case will be filed before the court, civil case against you, I'll tell you, judges, they are very liberal. California judges are very liberal. When I say liberal, they always interpret, number one, in favor of the complainant, meaning the employee. Number two, overreach, always broad. That's how they interpret a particular law. So take a look at this. AB 1825, which took effect in August 17, 2007. So employers with 50 or more employees, all of them must conduct this 2 hours mandatory training for supervisors. And the training frequency is once every 2 years. And within 6 months upon hire as a supervisor. And also, if promoted as a supervisor, within 6 months thereof, they must undergo this particular training. And then October 2017, SB 396, employers with 50 or more employees, they expanded the anti-harassment training to include gender identity, gender expression, and sexual orientation. In short, the LGBTQ community. You see, we have to include that. And this will be part of my presentation. And the training frequency is the same. Once every 2 years and within 6 months of hire or promotion. And this one was passed recently in 2018, SB 1343, which took effect on September 30, 2018. You see? Employers with 5 or more employees, they are required to conduct this training for all of their employees, but only 1 hour. And the training frequency is the same, once every 2 years and within 6 months of hire. So you see, California wants everyone to get educated. And when they get educated, you have to be very careful. They already know their rights. So as a supervisor, you have to be very careful on how you're going to conduct your day-to-day activities when you are in the workplace. Question is does your employer enforces or does it commit itself to have an environment in the workplace that would preclude or stop or eliminate cases of sexual harassment or sex discrimination in the workplace? The answer is yes. In your employee handbook, we have the non-fraternization policy. And specifically, these wordings here, I copied this word for word, or in the Latin term, in toto. Managers and supervisors, see? You are urged, okay, from engaging in personal or social relationships with your co-worker and with your employees that works under you in order to avoid cases of misunderstandings, complaints of favoritism, possible claims of sexual harassment. And not only that, as a result of a personal or social relationship, then there is a possibility that it will cause employee morale and dissension problems. You see? This next paragraph. So, you are being discouraged from fraternizing or becoming romantically involved with one another, and worse, with a subordinate in the chain of command, or with any non-company employee of a facility owned or operated by the company. E.g., you work in Los Palos, same thing. If you're going to have that romantic relationship or socially fraternizing with secrets, the same thing. It is a case of a sexual harassment. You see? So, what is the word here? Discourage. We discourage you. But we cannot stop you. It is your legal right. Because you cannot stop love. When you are in love, no one can stop you. You become drunk. You see? You become irrational. And so you get in love. So we cannot stop you. But you have to be very careful. Because too much being in love, tendency is you're too close with that co-worker or your rank and file, so it will cause dissension problem. Other employees, they see it. As far as they are concerned, they will consider that as a case of sexual harassment. Even though you don't subject them directly to a case of sexual harassment, there is such thing as a third-party sexual harassment or a bystander sexual harassment. If they see and they feel offended, then they can file a case against you. You see? And not only that, worse, if you subordinate and then you give preferential treatment to the subordinate that you're romantically involved, that is a case of perceived sex discrimination and a case of sexual harassment. Because if other employees in your department, you don't give them favor, and of course, because you're so in love with your subordinate, of course, you're going to give favors. Otherwise, he or she is going to break your heart. You see? I'm not talking about experience here. But I know the dynamics, how it works. All employees should also remember that the company maintains a strict policy against unlawful harassment of any kind, including sexual harassment. So, I'm warning you, managers and supervisors, be careful when you get in love. How about employees? Yes, employees are also covered. There is a non-fraternization policy. Just like you, the standard is the same. We discourage them to engage in personal relationship or to fraternize with co-employees, and more so with their supervisor because of its effects. It causes misunderstandings, cases of favoritism, and possible claims of sexual harassment, and worse, employee morale and dissension. So, your employer, therefore, maintains a strict policy against unlawful harassment of any kind, including sexual harassment. So, your employer, Los Palos and Seacrest, is committed to maintain a work environment that is free of discrimination. And we are committed. Your employer is committed. When I say your employer, it is you, because you belong to management. So you have this commitment to provide employees with a rewarding job experience and compliance with various laws, that you are not going to tolerate instances of harassment by employees, including anyone. You see, it's not only your employees, but including your vendors that comes into the building, or your visitors that comes in to your workplace, based upon all of these protected categories. See? Race, color, religion, sex, sexual orientation, gender, pregnancy, marital status, national origin, citizenship, veteran status, ancestry, age, over 40 years old, physical or mental disability, medical condition, genetic characteristics, or any other consideration made unlawful by applicable laws. So all of this that I just read to you, these are what you call protected categories or protected class. So if you are going to discriminate in any of this class, that is what you call discrimination. Sexual harassment only pertains to sex-based or gender-based. See? Which I'm going to explain later. So continue. So, harassment is usually unlawful only when it is severe and pervasive. No, but only when it meets certain specific criteria, which I'm going to discuss later. But it does not have to be severe and pervasive in that instance on certain occasions. The act itself, even though it is not pervasive, but if it's severe, a one-time act, boom, it's a case of sexual harassment. And so therefore, the company will not tolerate harassing conduct that affects tangible job performance or that creates an intimidating, hostile, or offensive working environment. So you see the consequences here? The company may discipline employees who violate this policy. See? Even if the employee's conduct does not violate the law. You see? So even though you are going to argue, well, the law does not state to the effect that it was considered a case of harassment or discrimination. No. Your employer has the right, the discretion, and the prerogative to make a decision if it runs against its moral corporate philosophy or corporate moral values. Then you can be disciplined, which may include termination. And in order to have an environment that is free from harassment and discrimination, our employee handbook also has a no retaliation policy. So anyone that is going to complain or file a complaint of harassment or discrimination, my friends, you have to attend to it. Attend to it with open arms. Welcome it. Take it in positive light. Because if you are going to retaliate against this employee, retaliation means you isolate this employee, neglect his or her complaints, and worse, you are going to undertake tangible disciplinary action or tangible action that is adverse, like demotion, not giving a salary increase if he is already due, or giving a good performance evaluation. That is considered to be retaliation. You see? And retaliation is a form of discrimination. So what is harassment in general? So harassment is a form of discrimination that is related to one or more of those legally protected personal characteristics of an employee, which I've already outlined. It is in our employee handbook. Race, gender, sex, sexual orientation. That is what you call personal characteristic. And harassment is an action verb. It's an action verb. See? It is a behavior which is personally offensive to a person that you are subjecting to, and that which impairs morale and interferes with the work effectiveness of employees. So they don't become productive. They become stressful, and some of them, worse, they become traumatized. You see? So, when you undertake this behavior in a work environment, that is called harassment. So, harassment based on any of these personal characteristics is illegal. 1 up to 17. California, 1 up to 23. So, you go through all of this, 1 up to 17. If you subject an employee or a co-worker to discrimination by reason of the race, and you just go through all of this, and that is what you call discrimination. Cannot do that. Let's move forward. So what is sex discrimination? So sex discrimination is a behavior that occurs when an employer makes a work-related decision, work-related decision, based on an employee's sex or gender. It can also occur when someone is treated differently because of his or her sex or gender. So if you are a male, you're a sexist, okay? You hate women, so you don't hire women for the job. Remember, it is not only during the course of employment, even during hiring an applicant. So you have an applicant who is pregnant, and then you are going to hire this applicant by reason of her pregnancy, that is considered to be sex discrimination. Because pregnancy is sex-based. Or, she's a woman, and among the 5 applicants, you hired all the 4 who are male, then she has a case of sex discrimination. So in other words, the decision that you make is consciously done based on a person's gender or sex. Oh, he is gay. Now, since he is gay, and you hate gays, okay, what do you call that? You are a homophobic. Homophobia. You're against LGBTQ. And so, instead of, you don't give good performance evaluation. And not only that, you don't give a salary increase, already entitled. And just coming to work late, you immediately write her up. Versus the rest, who are not LGBTQ, you don't write them up. Oh, that is considered to be sex discrimination. So, sex discrimination and sexual harassment, therefore, must always be sex-based or gender-based. So when we say sex-based or gender-based, these are the following. Of course, we already know what is sex or gender, male or female. Gender has been expanded to include gender identity, gender expression, under AB 887. It pertains also to your sexual orientation. Let me tell you the difference. Sexual orientation pertains to the lesbians, the gays, and the bisexuals. Sexual orientation. Their heart, okay? They are attracted to. See? Attracted to. That's why they are lesbians, gays, and bisexuals. Gender identity, they are not attracted. It is not their heart. But it is their mind that makes them believe that despite their biological system that they have, their genitalia, that they have, penis, okay? And yet they think that they are a woman. That is gender identity. You see? So, this pertains to transgender. And of course, when they think that they are a woman, then they have to express as a woman, right? They talk like a woman, walk like a woman. They do the makeup. Their hairs are long. They wear a dress. Oh, you cannot discriminate against them. You cannot tell them, hey, we better go home and change your dress. You have to be very careful. That is sex discrimination. So we go for it. Marital status, pregnancy and childbirth, breastfeeding. Remember, we have lactation law. We have to provide a private room to those mothers who are lactating. Now, if you don't, that is a case of sex discrimination. So, that is how we define. So, let me give you an example here. What is sex discrimination? So, you go through this. Carl has been a manager for the board for 5 years. Carl approaches another manager, Terry, and tells him that she identifies herself as a transgender woman and is beginning the process of transitioning at work. From now on, Carl would like to be called Kay. Will be wearing clothing consistent with an identity as a woman. and prefers the use of feminine pronouns. As the weeks pass, Kay's co-workers become accustomed to her new name and appearance. But some of them inadvertently refer to Kay as Carl and use the masculine pronoun he, especially when telling stories about things that happened before Kay's transition. Usually, the co-workers quickly correct themselves when this happens. Terry, however, pointedly says, "Good morning, Carl," when Kay passes by and makes comments like, "Nice dress, dude." Kay, embarrassed, says nothing to Terry or anyone else about these comments for months. Is this a case of discrimination? Remember, Carl is a male, but he identifies himself that he is a transgender. So from now on, Carl say, "Do not call me Carl, but Kay. And do not address me he, but she." See? But then, some of them still identify him as a male. Is this a case of sex discrimination? So what advice would you give Kay? My friends, you just go through this A, B, and C. The answer is B. Kay has a claim for discrimination and harassment because of gender identity and gender expression against the board, because of Terry's treatment of her, as well as because of her co-workers' occasional use of the wrong name and pronoun, even though it was inadvertent, because he already made it known. So you cannot have a good faith excuse. "Oh, sorry, I made him." No, cannot. So be very careful. Sex discrimination, that is a good example. Lan, I think one or two of them, I can hear their voice. Can they mute it? I get distracted. So what is sexual harassment? So sexual harassment, we already know what is sex discrimination, right? So what is sexual harassment? So sexual harassment is a form of sex discrimination that violates or is prohibited under Title VII of the Civil Rights Act of 1964 and under the laws of many states. See? Sexual harassment is a form of sex discrimination because it is sex-based, it pertains to gender-based. But the difference between sexual harassment and sex discrimination is this. Lan, can you hear me? Lan? Someone is on. I get distracted, Lan. Someone is on. Someone is talking and I can hear their voice. Can you perhaps check your computer? Kindly mute it. Okay, please mute all except me. Okay. So what is sexual harassment? Let's continue. So the difference between sex discrimination and sexual harassment. If you take a look at this, it is an unwelcome sexual conduct, see, which creates an intimidating, offensive, or abusive work environment on the basis of one's sex. You see what you have here? Unwelcome. So if it's welcome, therefore it is not sexual harassment. So if I kiss you, okay, in your cheek, and you did not react, you did not say no, then therefore it is welcome. And it is considered to be a sexual conduct. If I touch you, right? If I hug you, stroke your hair, that is considered to be a sexual conduct. If it is unwelcome, and if you feel and perceive that it created an offensive or abusive work environment, that is considered to be sexual harassment. Now, despite such, I am pretty sure that you are more or less confused. The fine distinction between sex discrimination versus sexual harassment. I have to make it clear to you so that you will have a good understanding. Sex discrimination is when you are discriminated against due to being, plain and simple, male or female. Yeah, because you're a male, you're a female, or you belong to the LGBTQ, or because you're pregnant, because you are married, see, or just because you just recently delivered a child. And I'm not going to consider your application for Family and Medical Leave Act. And I'm not going to promote you because you belong to the LGBTQ community. That is sex discrimination. On the other hand, sexual harassment is unwelcome advances in any of these forms, physical, verbal, visual, or environmental, which I'm going to explain later, of a sexual nature or received for sexual favors. So these things may also be discriminatory, but sexual harassment has the distinct difference of being harassing and sexual in nature. See? There is always a component of solicitation or a request in sexual harassment, and it is unwelcome. There is always this component of sexual in nature versus sex discrimination. So typically, sex discrimination is caused by supervisors, managers, or other people in power. Is the phone with you?
Yes.
It's Madeline. Tell her that I will just call her later. So sex discrimination is caused by who? Typically by you, managers, in the workplace. But co-workers are also potentially able to discriminate as well, right? Because you are a person in authority. You have the power. So you can discriminate an employee if he or she applies, right? Or in the course of employment, requesting that she be placed on this particular ship, or she wants to take off. Or in an employee is full-time, but because you are sexist, you are against this particular group, then you are the manager or supervisor, then you don't give that, put in the request, you're going to downgrade this employee from full-time to part-time. That is sex discrimination. So sexual harassment, on the other end, can be claimed by anyone who has been affected by sexual harassment in the workplace. So regardless, whether you're supervisor or non-supervisor, this is what normally happens in the workplace. Sexual harassment. These are unwelcome sexual advances. See? So I hope you have already differentiate what is sex discrimination versus sexual harassment. So let's go on with this quiz. Supervisors can be held personally liable for sexual harassment. True or false? The answer is true. You can be personally liable. 2. Employers can be held liable for the acts of its supervisors for sexual harassment. True or false? The answer is true. That's why I predicated. You are the agents of your employer. You belong to management. So even though your employer did not know that you committed sexual harassment, they could be made liable for your acts or even your omissions for failure to attend a case of sexual harassment that was brought to your attention. Employees can be held personally liable for sexual harassment. True or false? The answer is true. They can also be personally made liable. When I say personally liable, out-of-pocket expenses. Meaning, if you will be sued, your employer will be sued in court, and including you, for being the harasser. And if the jury will rule in favor of the complainant, you will be made liable. You will pay for the damages. See? Employers can be held liable for the acts of its employees for sexual harassment. True or false? Of course, the answer is true also. But there is a different level, which I'm going to explain later. So in other words, your employer will always be on the hook, whether it's the act of the supervisor or the non-supervisors or the rank and file. Quiz number 2. Non-employees are not protected against sexual harassment committed by employees. True or false? The answer is false. Remember vendors, your guests, third parties that comes to the building? If you subject them to sexual harassment, they can file a case of sexual harassment against you. And if they subject you to sexual harassment, then they could also be made liable. You submit your complaint to management, and management is going to contact the employer of this vendor. Employees are not protected against sexual harassment committed by non-employees. True or false? The answer is false. Because we have to protect you. If we can protect non-employees, more so our employees. We have to protect them against cases of sexual harassment. So who is protected by the law? Everyone. Everyone. See? Employees and non-employees. So if you take a look at this, including applicants, the non-employees, independent contractors, that render services in your building, volunteers also that comes to that works in your facility for free. Invited guests and visitors. See? So this pertains to family members that comes into the building. So who is liable under the law? Everyone are liable. Every person in the workplace. See? All of this. Even non-employees. So what is workplace? So a workplace is, of course, where we work, right? The building where you are. Because that is the workplace environment that you have. So it pertains to the company's premises or property. So company's premises or property could be your parking lot, right? So if you were subjected or you subjected in the parking lot, and even though you have already clocked out, it doesn't matter. If it's in the premises, that is a case of sexual harassment. Now, is it possible that it will also be a case of sexual harassment outside the workplace or off company premises or property? The answer is yes. The answer is yes. So, if you did an errand and you have a driver, company driver, you went to Home Depot to buy something, along the way, you subjected that employee to sexual harassment, considered sexual harassment. If you have a social gathering on occasion in a park, company-sponsored, or a Christmas party in one of the hotels, any sexual harassment that will happen there, okay, is considered to be workplace sexual harassment. Any seminars that you attend, perhaps in San Francisco or San Diego, with a co-worker that you were sent to attend. So if something will happen along the way, whether in the vehicle, or in the hotel, or in the room, anywhere, even though it's already non-working hours, it is still considered to be workplace harassment. So, what is workplace sexual harassment? So, we already know. Sexual harassment in the workplace is a form of sex discrimination that violates Title VII of the Civil Rights Act of 1964 and California's Fair Employment and Housing Act. And so, sexual harassment refers to unwelcome sexual advances, unwelcome, or other visual, verbal, or physical conduct of a sexual nature, and actions that create an intimidating, hostile, or offensive work environment. See? And that is the consequences based on an employee's sex. And we already know that. And California law has a definition of what else workplace sexual harassment is. It need not be motivated by sexual desire. So you cannot use an excuse. Well, you know what? I was not motivated by my lust. She's ugly. Why would I do that? Oh, my friends, in workplace sexual harassment, it is not considered an element. It is the act itself or how it has been perceived by the party. You see, perception. It doesn't have to be factually based. That he or she was subjected by you to sexual harassment, okay, by based on their sex or their gender, that is considered to be sexual harassment under the laws of California. See? So there are two types of sexual harassment. One is quid pro quo, something for something or this for that. Only supervisors are liable for this type of sexual harassment. Why? Because they are in a position of authority that can make decisions. And so you use your authority to solicit, to extort sexual favors. You see? So if they approach you, an employee, asking for a leave of absence, or asking for a vacation, a performance evaluation, or any forms, anything, and then you're going to use your authority in exchange for, my friends, that is considered to be quid pro quo. And if they fail to give in to your lust or sexual desire, you're going to terminate them, demote them. That is an act of retaliation and a case of sexual harassment. See? You demand. I want to have sex with you. Okay? After office hours, I want to see you in the motel. And if you don't do it, your request for salary increase, no, I'm not going to give it to you. That is quid pro quo. Only supervisors can do that. And even though by definition, you don't have to be to have the direct authority, but if an employee perceive that you are a manager or supervisor, you already fall under this definition. So, the essence of a quid pro quo harassment claim sexual is that a supervisor relies on his or her apparent or actual authority to extort sexual favors from an employee. And the threat may be expressed or implied. You don't even have to say it. But if you attempt, say for example, you know, a woman came in, a female employee came into your room, and you tell the female employee, can you kindly close the door, please? You see? And then you start to take your move. You stood up from your table, approach this employee, even without saying, and you tell her, you try to embrace her or kiss her. That is already considered to be a case of sexual harassment. You have to be very careful. See? And then you're going to say, okay, that's fine. If you refuse, then the following day, instead of full-time, you place it on part-time. See? The threat was implied. Because you refused yesterday to allow me to kiss you or embrace you, and then this is what would happen to you. See? So, occurs when an employment decision or condition is based upon whether the employee is willing to grant sexual favors. So, whether the favor has been granted, whether the employee that you subjected to sexual harassment has given it to you or not, it doesn't matter. The act itself is already considered to be consummated. Example, if you say, you know what, I want to have sex with you tonight. And don't worry, your long-standing request for a promotion, I'm going to recommend that to Nestor or to Mrs. Valdemar or to Josie. And then the woman refused. She did not, made it to her appointment in that motel that you decided where to meet. And then you say, yes, it's true. But it did not happen because she did not appear in the motel. My friends, the mere act of saying it already consummates it. See? And so, quid pro quo example, just to give you a better idea here. John supervises Irene at the company. They are traveling to a training seminar. They go to dinner together and later have several drinks. John then asks Irene to join him in his room for a few minutes to talk about a new position she has applied for. They have more to drink and John becomes more friendly. He tries to embrace Irene. She refuses his advances and returns to her room. 3 weeks later, John announces that promotion goes to another employee. See? This is implied. Threat. You see? This is still considered to be workplace harassment, even though it did not happen in the workplace. They were attending seminars. So this is a case of quid pro quo because he is the supervisor of Irene, using his authority to further his sexual advances. And it is not excuse that he was inebriated or drunk. That is not an excuse. So, it is a harassment case. See? It is. So you just go through this. Answer A, B, C. I will not read anymore because, due to lack of time. Here's another one. Blake, the sole proprietor of Acme Companies, decided to expand and compete for state contracts. Blair hires Jack, an independent contractor, to install a computer network. Jill responds to Blake's Craigslist ad for an office manager. Blake threatens to sue Jack for breach of contract unless Jack agrees to engage in sexual activity. Blake also tells Jill that job is hers if she agrees to have sex. This is quid pro quo. He is the owner of the company, sole proprietor, and he is leveraging his position to solicit sex with them. And if you don't, then I'm going to promote you. I'm not even going to argue. This is a classic case of a quid pro quo. Okay? So I don't have to go through this. You have the materials. This one is another example. I have to go through examples because this is the requirement of the training in sexual harassment. Sarah is the deputy director of a state agency. She approaches Nancy, an office technician, and says, "Hi, Nancy. I've seen you at the gym. You seem to have a great time in Zumba and so sexy. Nancy, I'd love to take you to Tahoe this weekend. Just the two of us." Nancy is stunned and intimidated by the attention. She says, "Well, Sarah, I'm flattered, but I'm not interested. Sarah smiles wanly and says, well, I had to ask. You are just so sexy, but I get it. I'll leave you alone. Sarah does not proposition or engage in any unwelcome conduct toward Nancy again. 3 months later, Nancy is late to work for 3 days and her supervisor